Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
On November 5, 2024, the Supreme Court on Banc approved AM number 24-02-06-SC, or the Rule on Family Mediation. The rule, which was drafted by the Supreme Court's Committee on Family Courts and Juvenile Courts, aims to address the emerging need for family mediation, both in the Philippines and abroad, enhance the efficiency of family courts by reducing their case backlogs, and promote the best interests of the child. What are the salient provisions in the rules, and how will these benefit families and the courts? Hi, I'm Atty. Navallo, Supreme Court Chief Communications Officer. It's the 21st of March 2025, and today we talk about the salient provisions in AM number 24-02-06-SC, or the Rule on Family Mediation. And joining us to talk about this rule is Court of Appeals Associate Justice Angelene Mary W. Quimpo-Sale. Justice Quimpo-Sale is a member of the Committee on Family Courts and Juvenile Concerns and the chairperson of the committee's sub-technical working group on the Rule on Family Mediation. Hi, Justice Quimpo-Sale. Thanks for joining us and welcome to the Supreme Court Podcast.
Oh, thank you very much, Atty. Navallo. It's a great honor to be invited to join you in this session.
Tell us what this family mediation is about and what prompted the Supreme Court to come up with this rule.
Okay, actually, family mediation is defined under the rule as a process in which a mediator, functioning as an impartial third party, facilitates the resolution of family disputes and supports the parties' voluntary agreements. It must be child inclusive, and it must uphold the best interests of the child and the family. And the factors that prompted the Supreme Court to come up with this rule was that the Supreme Court, through the Committee on Family Courts and Juvenile Concerns, the CFCJC, recognized that despite the availability of alternative modes of dispute resolution, like barangay conciliation and court-annexed mediation, there is a need for specialized training in handling child and family cases, particularly in hearing the voice of the child. And so this, coupled with the rising number of cases, family cases, impelled the CFCJC to address the gap and resuscitate the then inoperative rule on court-annexed family mediation, which was first approved in 2010. It was approved and family mediators were trained, but it did not proceed. There was no selection, there was no accreditation.
So, sure, this is the first time we're really implementing this.
Yes.
Oh, okay.
So we created a new rule and then implementing this rule and also the previous rule that was approved by the Supreme Court, which is incorporated in this new rule. So this is also a response to our international obligations and pursuant to our accession to international conventions involving children and family, such as the UN Convention on the Rights of the Child, the HCCH, Hague Convention on Private International Law, particularly in the 1980 Child Abduction Convention, and the 2007 Child Support and Family Maintenance Convention. And in addition to that, there is another international agreement. It's between the Council of ASEAN Chief Justices, which is composed of Chief Justices of 10 ASEAN member states, right? And in one of the working groups of the CACJ, this is the Council of ASEAN Chief Justices, one of the working groups there is the Working Group on Cross-Border Disputes Involving Children. And the chairpersons of that particular working groups, the Philippines and Singapore. And the family mediation was brought up in 2017 when a justice who later became Chief Justice, Teresita Leonardo de Castro, was the chairperson of that particular working group. And there was an ASEAN Family Judges Forum. And that was in 2017. And it was agreed among the CACJ members that family mediation be implemented in our respective countries.
So there are both factors here in the Philippines and outside that led to the crafting of these rules.
Exactly.
Right?
Yes.
And the question really, Justice, is why is family mediation necessary? I mean, what's the logic behind this? Why is there a need to at least amicably settle first if these are disputes within the family rather than going to court?
Oh yes, actually that is in the family code. That there
Mhm.
should be earnest efforts before a case is filed in court. There should be earnest efforts among family
Mhm.
members to try to settle the case amicably,
Mhm.
right? But when the cases are in court, still emotions are very high,
Yes.
and so with this one, it is not a regular mediator would find it not in their usually course
Mhm.
of mediating to find cases between family members, and particularly those involving children,
Mm.
when we have to hear the voice of the child,
I see.
a child inclusive practice.
Mhm.
So in this particular instance, there is a special training on how to handle people with high emotions,
Mhm.
to let those emotions subside,
Mhm.
and for later for the parties to come up to realize that they have to follow the best interests of the child,
Mhm.
and then make an agreement to keep the family solidarity.
Mm.
That is in the constitution,
Yes.
that the family should be kept solid,
Mhm.
and then it has also in the family code. So aside from the earnest efforts and the case is filed in court, so we can undergo family mediation,
Mhm.
and then and it doesn't only cover cases in the domestic front. It will
Mhm.
also cover cases in the CACJ and
Mm.
under those international conventions.
Mm. Mhm. So this rule, justice, the rule in family court mediation, what is this? It's a set of guidelines which include, as you mentioned, attempts to mediate at any stage of the proceedings in court.
Actually, they're specifically mentioned, the express mention in the rule of
Mm.
procedure. There's a condition precedent
Mm.
that they should avail of conciliation, alternative modes of dispute resolution before a case is filed in court.
Mhm.
But this particular condition precedent is the rule already took effect last December 29, 2024. But this
Right.
particular condition could not be implemented at this point in time,
Mhm.
because we have to wait for the proposed rule on pleadings and practice to be approved by the Supreme Court
Right.
on that particular requirement as a
Mm.
condition precedent.
I see. I see.
But when the case is already filed, cases covered under the rule, it's filed in court,
Mm.
mediation is covers two parts. It could be it's mandatory during the pretrial stage,
Right.
and after pretrial, during the course of the trial, if both parties agree voluntarily, they can avail of family mediation.
Mm.
And even the third stage, if a judgment has already been rendered, the
Mm.
judgment has been
Yeah.
rendered, and is now for execution of judgment, the parties, by agreement, they can still avail of family mediation. And this is expressed as stated in the 2007 Child Support and Family Maintenance Convention
Mhm.
of The Hague, HCCH Convention. So that's why that is also in our rule of procedure in Child Support Convention.
Right. So,
Actions.
so the intent really is at any stage of the proceedings, if there's a chance to settle, we'll go for settlement.
Yes, that's permissive. That's why we call
Right.
it permissive.
Right. Right.
It depends on the parties, and the court will allow them.
Mhm. Is family mediation applicable in all cases, or there are specific cases to which this rule applies?
Well, there are specific cases.
Mhm.
So actually, primarily, it's a specialized type of mediation that applies to cases within the jurisdiction of the family courts,
Mhm.
the first and second level courts, and the Court of Appeals, involving suits between husband and wife,
Mhm.
between parents and children,
Mhm.
among other ascendants and descendants, and among brothers and sisters, whether of the full or half blood. The rule shall also apply to relatives within the fourth civil degree of consanguinity or affinity,
Mhm.
and to parties in a common law, dating, or sexual relationship, whether former or current.
Oh,
So
so
it has
it's
to be-
not just married couples, even those in a live-in, so-called live-in arrangement.
Yes, partnership.
Mhm.
And it's mandatory. Would you like me to continue?
Yes, please.
Okay, thank you. On Section 3 of the rule, there are cases that are mandatory that should be referred to mediation. Number one, all cases involving issues under the Family Code of the Philippines and other laws, which can be the subject of a compromise agreement, such as support, custody, visitation, property relations and guardianship. Number 2, the settlement of intestate estates under the rules of court involving parties falling under Section 1. Section 1 meaning the relationship, family
Right.
relationship.
And when we say intestate, those without a will.
Yes.
Right.
And then number 3, cross-border disputes in international child abduction, support, custody and visitation, guardianship, and other civil cases involving children filed in the Philippines between a Filipino residing in the Philippines or temporarily residing abroad and a citizen of a member country of the Council of ASEAN Chief Justices, the CACJ. It's here. And then, last, other civil cases or the civil aspect of criminal cases where mediation is allowed by law. The rules, international conventions, or agreements, and the like, provided that the parties fall under Section 1 of this rule, relationship.
Right, we go back to the relationship.
Yes.
Right, so I noticed, Justice, that the emphasis on cross-border cases, are there really a lot of cases like this that we come across in our courts?
As of now, not yet.
Not yet.
Not yet. But we have heard already because the Department of Justice is a central authority. They are the administrative agency in implementing that convention. They have their own rules of procedure there. And they said that they already have cases before them.
Right.
Because they can refer those cases to the court if the cases could not be mediated at their end.
Level.
Yes.
So they also have their own mediation from their end.
Exactly. That's also one of the
interesting.
reasons why we created this rule and we discussed that we have family mediators because they also need family mediators on their end.
Are there also cases, Justice, that are not subject to family mediation?
Oh, yes. Yes. And it's stated there in the rule. Number 1, it's Section 4, civil cases which cannot be the subject of a compromise, the civil status of persons, the validity of a marriage or legal separation, any ground for legal separation, future support, the jurisdiction of courts, and future legitim. This is in the Civil Code.
Yes.
And then number 2, habeas corpus, unless it relates to custody of minors. Letter C, violations of Republic Act number 9262, the Anti-Violence Against Women and Children Act of 2004. Letter D, number 4, all cases involving issues under the Family Code of the Philippines with application for protection orders, restraining orders, preliminary injunctions. But there is an exception to this. However, in cases under paragraphs A, C, and D, A being civil cases, C the 9262, RA 9262, and D protection orders and restraining orders, and under the rule on international child abduction cases, where the parties inform the court that they have agreed to undergo mediation on some aspects thereof, such as the custody of minor children, separation of property, or support pendente lite, the court shall refer them to family mediation.
I see. Now that we know, for example, what topics are subject to mediation, what are not, what are the responsibilities of the courts, Justice, when it comes to family mediation? What should it do?
The court, they need, before the family mediator takes in the case, there must be a referral from the court. So that's really...
So it's really the court that triggers this mediation?
Yes, when the case is already filed in court. But this does not close our door to the condition precedent. So that is before the case is filed in court.
Right.
But as I stated earlier, we have to wait first for the action of the Supreme Court on the proposed rule on pleadings and practice regarding condition precedents for cases to be filed in court.
Is there a timeline for this, Justice? Are we looking at this year, next year perhaps?
I could not say at the moment because we are not part of that committee that prepared the pleadings and practice.
Right. So for this condition precedent, since it can't be complied just yet, so what happens now to existing cases? They will still go through mediation, or will the case continue in court? What happens?
Oh, when we already have family mediators. At the moment, we still don't have family mediators. So they just they follow the regular rules.
Regular rules.
Yes.
So that means we can't refer this yet to family mediators because the condition precedent is not yet available. We can't comply with it yet.
Yes, number 1. The second thing is that we still do not have family mediators.
Oh.
We are starting our sub-technical working group, we had the meeting this month. And then we are already preparing the training program, and also when will the PMD, the Philippine Mediation Division under the Office of the Court Administrator, open up applications for those who are interested to be family mediators.
I'm sure many will probably watch out for that, Justice. No, but going back to our discussion, what happens if, for example, mediation is successful? Will there be an order immediately resolving the case?
Oh, yes. Yes, that will, if mediation is successful, it's there in the rule itself that the parties shall prepare the compromise agreement with the assistance of their respective counsel, and the family mediator shall make available samples or templates of agreements to assist the parties in preparing their own agreement. And upon termination of mediation proceedings, the family mediator shall submit the mediator's report, copy furnished the Philippine Mediation Unit for their statistics, together with any or all the following: the original compromise agreement, the motion for withdrawal or dismissal of the complaint, and the parties' claims and counterclaims, and the proof of satisfaction of claims or any other relevant document, especially when there's a support of a child.
Yes.
And to show that indeed that they have already started giving the support. Financial, or if there's something about emotional, psychological, it should also be there. And
these documents, Justice, are mandatory in the sense that if you're not able to show that, for example, you can prove that you're already providing support, can the agreement or the settlement be rescinded if it doesn't comply with these requirements?
No, not necessarily rescinded. The court can perhaps inform them that you should include this or what, or if there's a provision there on future support, which is not valid. Right? Then the court can inform them.
Right.
But actually, that will also be part of the training for family mediators. That you're only for these kinds of subject matter that you can delve into.
Right. Now, what if it's the other way around, Justice? What if the mediation is unsuccessful for maybe one or even both parties cannot agree? What happens next?
So they just go back to court. There will be a report as usual, like the mediator will give a report that is back to court.
And the proceedings will continue.
Yes. And in the rule on international child abduction, the judge can do the mediation himself.
Yes.
Or even JDR can also be conducted under pre-trial. JDR can, I mean under the present rules of procedure, JDR.
Judicial dispute resolution. Right. Now, is it within a party's right, Justice, to refuse to undergo family mediation, or are there sanctions in case they refuse?
Well, it's there. They said that if the parties refuse to undergo mediation, a party cannot refuse family mediation, as the rule provides that it is mandatory. In case a party refuses, the PMU staff shall immediately submit a back-to-court report to the referring court on the date such refusal to undergo mediation becomes evident. This refusal is not without any consequence. If the plaintiff, petitioner, and counsel refuse without justifiable reason, the case shall be dismissed. If it is the defendant or the respondent who refuses without justifiable reason, the plaintiff or petitioner shall be allowed to present evidence ex parte, and the defendant respondent's counterclaim shall be dismissed. This is found in sections 14 and 15 of the rule.
So there are consequences depending on what's your participation, if you're the plaintiff or if you're the defendant in the case.
Yes.
Interesting.
And justifiable reason.
For justifiable reason, which is, of course, subject to the discretion of the judge.
Yes.
What is justifiable.
Yes.
Right. Now, what happens, Justice, because sometimes during the case, things can get heated during mediation. There could be outbursts, there could be high emotions or even actions that they may regret later on. But if someone acts inappropriately or contemptuously, what will happen? Can they be sanctioned?
Oh, yes. That's pursuant to the regular rules of procedure in mediation. But I would like to point out that here in family mediation, why is this highly specialized? Because the family mediators will be trained to handle cases that are highly emotional. Because I was a family court judge for 12 years, and I did mediation myself.
Right.
And I did it in court, and it showed that these cases are really highly emotional.
Right.
And we have to let those emotions subside
Mm-hmm.
for the mind to take over the emotions.
Yes.
Even when there are heated discussions and the family mediator with all those emotional outbursts, and he or she sees that there is something, like there is a need for counseling, that family mediator can refer or request the court for the assistance of a court social worker,
Mm.
for the assistance of a psychologist, or even a psychiatrist, or any person that can render support services to the parties, to the party or parties, or the child involved in the case. Support services.
I see.
So that is also part of the training for the
Mhm.
family mediator, to make that kind of assessment,
Mhm.
that they can see it, that indeed there is a special need here. So
Mhm.
they can request the court for the parties to avail of those support services.
Mhm. Mhm.
So that's why it's a different kind of mediation.